Contributory negligence is a legal doctrine that holds a person partially responsible for their own injuries or damages if they have failed to take reasonable care to avoid the harm. History of contributory negligence. The concept of contributory negligence has its roots in ancient law, where it was known as contributio. The Roman jurist Ulpian defined contributio as the contribution of one's own fault to the harm suffered. Over time, the concept of contributory negligence evolved and was adopted by various jurisdictions, including the United States, the United Kingdom, and Australia. Elements of contributory negligence. To establish a claim of contributory negligence, the following elements must be proven. Fault. The plaintiff must have been at fault in some way, such as failing to take reasonable care or ignoring a known danger. Contribution. The plaintiff's fault must have contributed to the harm suffered. Causation. The plaintiff's fault must have caused the harm suffered. Damages. The plaintiff must have suffered damages as a result of the harm. Types of contributory negligence. There are several types of contributory negligence, including active negligence. Active negligence occurs when a person actively contributes to their own harm, such as by ignoring a known danger. Passive negligence. Passive negligence occurs when a person fails to take reasonable care to avoid harm, such as by failing to wear protective gear. Gross negligence. Gross negligence occurs when a person shows a reckless disregard for their own safety or the safety of others. Examples of contributory negligence: failure to wear a seatbelt. A person who fails to wear a seatbelt while driving may be considered to have contributed to their own injuries in the event of an accident. Ignoring a warning sign. A person who ignores a warning sign and fails to take reasonable care to avoid a hazard may be considered to have contributed to their own injuries. Failing to follow safety procedures. A person who fails to follow safety procedures, such as wearing protective gear, may be considered to have contributed to their own injuries. Defences to contributory negligence. There are several defences to a claim of contributory negligence, including assumption of risk. A person who assumes a risk and takes reasonable steps to mitigate it may not be considered to have contributed to their own harm. Comparative negligence. A person who is partially responsible for their own harm may be able to recover damages, but the amount of damages may be reduced. Waiver. A person who waives their right to claim contributory negligence may not be able to do so. Application of contributory negligence in various jurisdictions. Contributory negligence is a widely recognized concept in various jurisdictions, including United States. The concept of contributory negligence is recognized in the United States, where it is often used to determine the amount of damages in personal injury cases. United Kingdom. The concept of contributory negligence is recognized in the United Kingdom, where it is often used to determine the amount of damages in personal injury cases. Australia. The concept of contributory negligence is recognized in Australia, where it is often used to determine the amount of damages in personal injury cases. Contributory negligence is a complex and nuanced concept that is widely recognized in various jurisdictions. To establish a claim of contributory negligence, the following elements must be proven: fault, contribution, causation, and damages. There are several types of contributory negligence, including active negligence, passive negligence, and gross negligence. Defences to contributory negligence include assumption of risk, comparative negligence, and waiver. In conclusion, contributory negligence is an important concept in the law that can have significant consequences.